Imagine carrying a heavy backpack filled with rocks every single day. Each rock has a word scratched on it. One says fear, another says waiting, another says what if they say no. You carry this backpack everywhere. It digs into your shoulders. It keeps you awake at night. It makes every step feel harder than the last. But what if I told you that right now, in this very moment, you are allowed to take some of those rocks out? What if I told you that the scary news flooding your phone is not the whole story, and that January 2026 actually brought some real relief for immigrants just like you? If you have been losing sleep over your immigration case, if you have been refreshing that USCIS case status page over and over again, if your family group chat is packed with terrifying headlines about deportations and visa denials and rules that feel impossible to follow, then I need you to stop everything right now. Take a breath, listen closely. Today, I am going to share real, honest, fact checked immigration news that could change how you feel about your future in America. This information comes straight from official government sources, not from rumors on the internet. January 2026 has brought changes that many immigrants never dreamed they would see. I'm going to walk you through every single one of them with total honesty and crystal clear explanations. I will only share information you can truly trust. Welcome back to Global Immigration Updates. My name is Sakib. My promise to you is very simple. I will never blow up your fears just to get more views. I will never use your worry to trick you into watching. I will only bring you immigration news that has been carefully checked against real government sources. I will always tell you what is true, what is just a rumor, and what you actually need to do to keep yourself and your family safe. Before we go any further, I want to make something very clear. When I say there are major wins for immigrants right now, I am not trying to shock you or make this sound like a movie trailer. I am talking about real solid changes that you can look up and verify for yourself. These are changes in how policies are carried out, these are improvements in how fast cases are processed. These are administrative changes that have already started happening, or they are in the final steps of starting as we enter January 2026. These are not promises made by someone running for office. These are not bills sitting in Congress that might never become law. These are real changes touching real people's lives at this very moment. I am going to explain each change with enough detail so you can understand exactly what it means for your own life and your own case. Let us start with one of the biggest changes affecting people who apply for employment based green cards and their families. For many years, people have been fighting for this. There have been court cases. There have been long delays, but now we are finally seeing real action on expanded work authorization protections for H-4 visa holders and certain dependent visa categories. Think about families who have been waiting in the green card backlog for 5 years, 10 years, sometimes even 15 years or longer. For these families, having both spouses able to work has been a lifeline that keeps food on the table and a roof overhead. In past years, there was a lot of fear in immigrant communities that the H-4 EAD programs might be ended completely. That fear caused huge anxiety for so many people. But what we are seeing in January 2026 is not just that these programs are still alive. We are also seeing the renewal process become much smoother and faster. Processing times have gone down by a lot compared to what people had to deal with in 2023 and 2024. I want to stop here for a moment and talk about something spreading on social media. Some content creators are saying that H-4 EAD holders never have to file renewals anymore. They are saying work authorizations have become automatic and permanent. This is completely wrong. The real improvement is that the government is processing things faster. They are asking for less extra evidence than before. There is better coordination between your work authorization papers, your document renewals, and your underlying visa status extensions. But here is what you still need to do. You still have to file your renewal applications. You still have to check your USCIS case status. You still have to make sure your status stays valid through the whole process. Please do not let viral lies make you miss an important deadline. If you miss a deadline because you believed a false rumor, it could hurt your case badly. The second big change I want to talk about has to do with the green card backlog. This especially matters for people from countries that have historically faced the longest waiting times because of the per country limit system. The basic structure of these per country caps is still written into law. Only Congress can change that completely. But what we are seeing in January 2026 is that the visa bulletin numbers are moving forward in ways that many experts did not expect. This is happening because of several things working together. Previous laws included provisions that recaptured unused visa numbers, and those are now helping. Consular processing capacity has improved a lot since the pandemic backlog started clearing up. USCIS service centers are also working more efficiently. All of these factors together have caused several employment based categories to move forward. This is giving real relief to applicants who have been waiting for many, many years. I want to be very careful when I talk about this because I know false hope can hurt you deeply. When your immigration case affects every part of your life, getting your hopes up for nothing can feel devastating. I am not telling you the green card backlog has disappeared. I am not telling you that everyone in the EB2 or EB3 categories from backlog countries will get their green card this year. What I am telling you is this: the direction we are seeing in January 2026 shows real, meaningful progress. This is very different from the stagnation and retrogression fears that filled everyone's conversations in previous years. If you are an employment based green card applicant, the most important thing you can do right now is make sure your employer's immigration lawyer is checking the visa bulletin every single month. You also need to make sure your priority date is recorded correctly in your pending adjustment of status application. Now, let us talk about family based immigration. This affects millions of families all across the United States. For those of you going through the marriage green card process, there is some truly good news about processing times at several USCIS field offices. In previous years, USCIS announced they were going to spend money on hiring more people, building better interview scheduling technology, and improving case management systems. That investment is now paying off. Wait times for adjustment of status interviews have gone down in many areas. This does not mean every marriage based case is getting approved super fast. Cases that have complex legal problems, past immigration violations, signs of fraud, or issues that make someone inadmissible will still take longer. Those cases might still get sent to specialized units for extra review, but for straightforward cases where both spouses have clear paperwork, a real and genuine relationship, and no complicating factors, the experience in January 2026 is noticeably better than what people had to go through in 2022 and 2023. But there is another thing I want to address about marriage green card applications. I have seen this question come up again and again in recent weeks. Some applicants have heard rumors that USCIS is being less strict on marriage based cases. They have heard that interviews are being skipped more often. Let me tell you what is really happening. USCIS does have the power to waive interviews in certain cases. Recent policy guidance has made clearer who qualifies for an interview waiver. But this does not mean USCIS is being less careful. It simply means they are using their resources more strategically. Cases that show clear signs of fraud, big age differences between spouses, limited proof of the relationship, or other red flags are still getting full reviews and in person interviews. If you are filing a marriage green card application, you should get ready as if you will definitely have an interview. Gather thorough documentation that proves your relationship is real. Do not make assumptions about your case just because someone else had a different experience. Every single case is looked at individually. The third area where we are seeing real positive changes has to do with humanitarian protection programs. This specifically includes temporary protected status and related programs. January 2026 has brought extensions and redesignations for several TPS covered countries. This means hundreds of thousands of people will keep their protection and their work authorization. Without these extensions, these individuals would have to face impossible choices about their futures. For TPS holders who have been living in legal limbo, not knowing if their protection would continue, these official announcements bring true relief. The Department of Homeland Security has published notices in the Federal Register. These notices confirm the extension periods. They confirm the re registration windows. They also confirmed that employment authorization documents will be automatically extended for eligible TPS beneficiaries during the re registration period. Once again, I have to address the misinformation that is going around. Getting a TPS extension does not mean the rules for green card eligibility have changed. TPS is temporary protection from being removed from the country. It gives you work authorization, but by itself, it does not create a path to permanent residence. Some TPS holders might be eligible for a green card through other paths, such as family based petitions or employment based sponsorship. However, having TPS status alone does not make you eligible for a green card. If you are a TPS holder and you want to explore permanent residence options, you need to talk to a licensed immigration attorney. That attorney can look at your complete immigration history and figure out if any pathway exists for your specific situation. Let us now talk about what is happening with student visas and academic immigration. For F1 students and STEM OPTI participants, January 2026 brings continued stability to the optional practical training program. This is the program that lets international students gain work experience in their field of study after they graduate. In past years, there were fears that OPP might be terminated completely. People worried there would be dramatic changes to STEM extension eligibility. Those fears have not turned into actual enforceable policy changes. Students who keep their F1 status valid, follow all program requirements, and file their OPT applications on time are still getting approvals within normal timeframes. Looking at current USCIS data and official announcements, I am actually seeing an improvement in processing times for Form I-765 OPT applications. This is much better than the severe delays we saw during the worst parts of the pandemic. This is truly good news for students who need their work authorization on time so they can start working for companies that might eventually sponsor them for an H-1B visa. Speaking of H-1B, this is an area where I want to be very careful and precise because it affects so many people who watch this channel. The H-1B visa program is still running under the registration system that was set up in previous years. The registration period for fiscal year 2027 will open in the coming weeks. This is for prospective H-1B beneficiaries and their sponsoring employers. There are a few key developments you should know about. There is ongoing implementation of beneficiary centric selection. This system is designed to cut down on multiple registrations being filed for the same person. USCIS is continuing its efforts to find and stop fraudulent registrations. There are also processing improvements for approved registrations as they move through the petition phase. I want to be completely honest with you about the H-1B situation. The demand for H-1B visas is still dramatically higher than the legal limit set by law. The selection process is still a lottery for cap subject positions. Getting selected in the lottery does not mean your petition will automatically be approved. The petition still has to prove that the job qualifies as a specialty occupation. It also has to prove that the beneficiary has the required credentials and qualifications. What January 2026 brings is not a magic fix to these basic realities. Instead, it brings improved integrity to the selection process and better processing efficiency for the petitions that do get selected. Now, I want to take a moment to talk about something that does not get enough attention in immigration news coverage. That is the importance of understanding what has not changed. Immigration law in the United States is created by laws passed by Congress and signed by the President. Major changes to who can get a visa, how many green cards are available, and what the requirements are for naturalization all require new laws to be passed. This is why I always warn viewers not to believe claims that everything has changed overnight because of one announcement or executive action. Executive actions and agency policy changes can affect how existing laws are carried out. They can change enforcement priorities, they can change how certain decisions are made, but they cannot override the actual requirements written into law. When you see headlines claiming massive changes to immigration, your first question should always be this: is this a change in the actual law? Is this a change in policy? Or is this simply a change in how someone is interpreting or reporting what has already been happening? As we enter January 2026, the core legal framework of immigration law remains the same as it has been. The Immigration and Nationality Act still governs visa classifications. It still governs admission requirements. It still governs the reason someone can be found inadmissible or deported. It still governs the path to permanent residence and citizenship. What has improved is how that framework is being administered. Cases are being processed more efficiently, decisions are being made more fairly. These improvements are happening within the authority that the law already gives to USCIS and other agencies. For everyone watching this video, no matter what visa category you hold, no matter what petition you have pending, and no matter what your immigration goals are, I want to give you some practical advice that applies to everyone in this current environment. First, check your case status regularly through official USCIS channels. The Case Status online tool on the USCIS website is your most authoritative source for knowing where your application stands. Do not rely on processing time estimates you see on social media. Do not assume your case should move at the same speed as someone else's case. Check your official status yourself. Respond quickly to any requests for evidence or notices you receive from USCIS. Second, keep your underlying status valid. Do not let any part of your immigration situation expire while you are hoping something might change in the future. If your visa stamp is about to expire, if your work authorization is nearing its end date, or if your status needs an extension, take action well ahead of time. Do not wait until the last minute, hoping that some new policy announcement will change what you need to do. Third, keep thorough documentation of everything. Whether you are going through a marriage green card process, an employment based green card case, or any other immigration matter, your documents matter enormously. Keep copies of everything you filed, keep copies of everything USCIS sends you, keep copies of everything that supports your case. This protects you if something gets lost. It protects you if there are questions about your case history. It protects you if you need to prove eligibility for future benefits. Fourth, be extremely careful about immigration advice you get from people who are not attorneys. Social media groups, community forums, and well meaning friends often share information that is incomplete, outdated, or just plain wrong. What worked for someone else's case might not work for yours. What was true under previous policy may have changed by now. What seems like simple advice might actually have complex legal implications. If you are making big decisions about your immigration case, talk to a licensed immigration attorney who can review your specific circumstances. I also want to remind everyone that the information I share on this channel is general educational information about immigration law and policy. It is not personal legal advice tailored to your individual situation. I do not know the details of your case. I do not know your immigration history. I do not know your personal circumstances. I do not know the specific legal issues that might affect your eligibility for benefits. Please always verify information through official government sources such as a CIS, a Department of State website, and the Federal Register. Consult with qualified legal counsel for guidance on your individual case. As I wrap up this update on the major wins for immigrants that January 2026 has brought, I want to leave you with a message that I hope gives you real reassurance. The immigration system in the United States is complicated, it is slow, it is often frustrating, but it is also a system where millions of people successfully navigate the process every single year. They receive their green cards, they become citizens, they build the lives they dreamed about when they first started their journey. The improvements we are seeing in processing times, the stability in key programs, and the continued existence of paths to legal status all represent real, meaningful progress. Do not let fear based content creators convince you that everything is falling apart. Do not let viral misinformation push you into taking actions that could hurt your case. Stay informed through reliable sources. Stay prepared by keeping your documentation and status in good order. Stay connected with qualified legal help whenever you need it. And stay hopeful because the wins we are seeing in January 2026 are real. More importantly, they are touching real people, real families, and real futures. If this analysis has been helpful to you, I truly encourage you to subscribe to Global Immigration Updates if you have not already. This channel exists to give you accurate, verified, trustworthy immigration news. We respect your intelligence and we respect your anxiety in equal measure. By subscribing, you make sure you get immediate notification when important developments happen. You will know right away when new USCIS updates are announced. You will know when you need to take action to protect your case. Please share this video with anyone in your community who might be affected by these developments. Share it with anyone who has been worried about immigration news they have seen somewhere else. Accurate information is one of the most powerful tools we have against the anxiety that immigration uncertainty creates. You can be part of spreading that accuracy. Finally, please leave your questions and your thoughts in the comments below. Tell me what specific immigration topics you want me to research and analyze. Tell me what concerns are weighing on you as you navigate your own immigration journey. I read your comments, I hear your concerns, I use your questions to guide future content that serves this community. Thank you for trusting Global Immigration Updates with your time and your attention. I will keep bringing you the verified facts, the honest analysis, and the reliable guidance that you deserve. Until next time, stay informed, stay prepared, and take care of yourselves and your families.